All rise. Fourth District Court of Appeal, First District is now in session. All those with cause plead to all nine, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Be seated. Morning, ladies and gentlemen. I guess we have 3 cases on the docket, and we will be taking a break after the first case, and we would ask that you would join us for coffee in the Dean's Suite, which I guess is room 370. And with that, we'll call the first case, Unifirst Corporation. Counsel ready to proceed?
Yes, Your Honor. Good morning, Judge Ben, Chief Justice Hawks, Judge Thomas. Kevin Sanders on behalf of Unifirst. I trust that the appellate brief has been read, and you may have questions on that, but what I'd like to concern myself with the court's permission, is what evidence is currently before the court for consideration. And I read from the record. In order to know where we're coming from, I think we need to know what the arbitration order was in this particular case, and that helps, I think, clarify the facts of this case, because I believe that there have been some facts misstated in the respondent's brief. The arbitrator in this particular instance is a gentleman who's very familiar with cases of this type. It was Roy C. Young. This arbitration was conducted in accordance with the contract in Tallahassee. When he made his award, he indicated the respondent, the City of Jacksonville, received several notices from the AAA, the American Arbitration Association, of the April 14, 2008 final hearing. Accordingly, the respondent had full notice and opportunity to attend and present evidence and argument before me at that hearing. However, the respondent failed to attend the hearing. Under Rule 29 of the Commercial Rules of the American Arbitration Association, he says in paragraph 2.
Well, can you make anybody you want a respondent? I mean, isn't the real question here isn't whether or not the city lost at arbitration, but isn't the real question whether or not the city was even obligated to respond to this arbitration?
Well, and again, I think you're going to the argument that I made that there's an invalid contract. And I believe, again, the evidence shows that there is a valid contract. Again, we've argued that in the brief. We believe that they have addressed that, at least under equitable estoppel. We put that in our reply brief. We've also addressed that with regards to our brief, that there was sufficient notice and sufficient evidence with regards to that. Things that I would point out.
But you agree that the court was the appropriate entity to make that decision about whether there was a contract that required arbitration?
Not according to the case law research that I did and I placed in my brief. I think that the cases that were cited by the city at the particular hearing before the lower court indicated otherwise. But true reading of that shows that there's a 2-pronged test based on that case law. The first prong basically says if you're challenging the arbitration clause itself, as best I recall from the reading of that, then that would be a matter for the court. But if you're just generally challenging the validity of the entire contract itself, that is a matter for the arbitrator to make a decision. And that's why I believe that the arbitration order is very key evidence in this, because all those matters were considered.
That sounds like it might be backwards. Why shouldn't the court why shouldn't the court decide whether there's a contract?
Well, and again, if you look at Chapter 682 under Subchapter 4 of 682, and I think under Subchapter 1, it depends on which one, if you're trying to move to enforce arbitration or if you're trying to move to stay arbitration, you have to file an action with the court to do that. The case law that's been cited for the justices here to review the data that was cited by the City of Jacksonville, all that case law, none of that occurred. That's what makes this clearly a case different. There was never any subsequent choice or challenge to the arbitration. There was never a motion filed under Florida Statute 682 to stay the arbitration proceedings. And again, the arbitrator in his order basically said that there was sufficient notice to the City of Jacksonville, and he proceeded under Rule 29.
The city made no secret of his position, right? Didn't it tell you that we're not going to be there? The contract never came into being because the signature by the purported representative of the city was ultra vires.
Well, and again, you are assuming facts that I believe, as the appellant, is not in evidence. The entire record is deficient with regards to any argument that would support that theory that the city put up in front of the lower court. The only testimony that came out in front of the lower court was regards to an alleged records custodian. And the records custodian even admitted, and I can quote that, that's also part of the record, he admitted under cross-examination, page 43 of the transcript says, I said, question, okay, well, what about the exhibits packaged here today? Were you the one that did all the research, and did you, or you're the one who pulled all these documents together? The procurement staff assisted in gathering these documents. He didn't even gather them. I said, so you didn't have anything to do with putting this package together? No, I didn't. He basically tried to verify documents that he never even put together. He never even really knew or what he had a staff put together to do that. And again, he didn't have any knowledge concerning the surrounding facts of this particular contract. He basically came allegedly and testified that the validity of these documents, these are the documents involved in this particular action. So I don't believe that there was any evidence presented that Mr. Amos truly did not have authority. Mr. Amos, it's not in the record, but Mr. Amos had passed away, so he was not available.
But I mean, the contract says that he works for the tax collector's office, right?
Well, and again, the entire...
I mean, could your client go on and sold anything to anybody in the city of Jacksonville, and they sign a statement saying, I have authority to sign this, and then the city is on the hook?
Well, and again, I think it goes back to the argument that we have of apparent authority and equitable estoppel. If you look at page 25 of the record...
But what did the city do to mislead you on equitable estoppel?
Well, again, I can go back then to the testimony of Richard Weghorst, who is the only individual who actually testified to evidence that occurred during the course of this event. And that starts...
Isn't the rule that you cannot recover against the city or any other public body on an apparent authority theory? Otherwise, any misfeasant public employee could drain the public fisc.
Well, and I would disagree with that in principle, and again under the equitable estoppel theory that I have in my reply brief. The Oxford shirts, which are the part of the contract, and again the contract is at page 25 of the record. These are Oxford shirts that were not a part of any bid. They were not a part of the bidding process. If you look again at the exhibits, and again I will flip to page 73 of the exhibits, or the record, excuse me, on appeal. The polo shirts, which are Oxford shirts that are a matter of this particular contract, which is in 25, are not a part of this bidding process. And the bidding...
I have to say, what on earth, what were these shirts for? These were for the tax collector's office?
They were for the tax collector's office. They were, according to the testimony of Mr. Weghorst, who works for Unifirst, there were 8 separate offices. He met multiple times over the course of a month with approximately 6 to 8 people who held themselves out as city employees. And this is the testimony that's on the record, and the only testimony on the record with regards to how this contract was entered into. They held themselves out as having the ability to negotiate and work the contract out. The facts as set out by the city in its reply brief are not facts that were in evidence before the lower court.
Do they wear the shirts?
That would be correct, Your Honor. They basically, there's 900, and I think according to Mr. Weghorst's testimony in the record, 913 employees of the tax collector, which is involved in 8 different offices. Normally, a shirt of a rental would be just an applique, something that could be either removed and the shirt could be put back in the circuit. The tax collector, and again, the process of the negotiation, which is a part of the record and part of the testimony of Mr. Weghorst, basically, they wanted it embroidered. That basically permanently damages the shirt. If you cannot take the stitching out, or if you try to take it out, you'll just see a bunch of holes and rag tags where the embroidery used to be.
So the city argues that the procurement process is essentially codified in the city charter, establishes a central procurement procedure. Your client is a sophisticated entity that has legitimate contracts. I'm not asking you to say this is illegitimate, but it has, you mentioned the bid, the contracts that went through that normal process, right?
Well, and again,
He has a legitimate contract that's not in dispute, right?
well, the bid is totally separate.
Right.
And again, it was never really a
Never
part
challenged.
of, never challenged or a part
That's
of.
part of the process that went through the central procurement procedures that's codified in the city charter.
Correct. And again, though, if you look at the record, and that's what I'm trying to stick with today, on page 121 of the record, you can see where the city of Jacksonville paid on this contract. The contract that they claim is invalid, the contract that they claim doesn't exist, they paid on this contract, and according to the testimony of Mr. Wakehorse contained in the transcript, for nearly 2 years. And if you'll look, in addition, again, referring to the evidence that's before this particular tribunal, it says, starting at 126, and there are statements from Unifirst that went to the city of Jacksonville. 127, 128, there's multiple samples of it. Down at the bottom, left-hand corner of that contract, of that exhibit, it says clearly on it, it says, service herein is rendered pursuant to a written contract with Unifirst Corporation or Unifirst Holdings LLP. So this was sent out weekly. These were weekly invoices for weekly services with the city of Jacksonville. And they're saying, okay, well, Mr. Amos didn't have authority to sign it. Well, did the person paying it have the authority to ratify the contract and to do that? Was he given the authority by the mayor and for the city council to make those payments? They made approximately, if you do 2 years times 52 weeks, they made approximately 104 payments to later come back and say, no, he didn't have the authority, and therefore all the money that you've spent, all the time that you put into closing, again, this is testimony from Mr. Wakehorse, all the time that you spent putting it, buying it, all this is an upfront expense for Unifirst. They have to buy the suits, the shirts, they have to buy the pants, they have to embroider them at their own expense, and they only get their money back at the conclusion of the contract. I did want to leave some time for rebuttal, but I will continue to answer some questions if I possibly can. I'll leave approximately this 3.5 minutes for rebuttal.
Please the court. My name is Carol Miranda for the City of Jacksonville, Office of the Tax Collector. I think I'd like to start by addressing some of the points that were brought up by Your Honors in Mr. Sanders' presentation.
How about the point that he just brought up? 104 payments, and then suddenly we don't know what's going on.
Well, Your Honor, there was a valid contract that was bid by Unifirst and awarded by the city. This is a supply contract for uniform services. And there is evidence in the record that the city presented below to the court that the city had paid for those uniform services to Unifirst through this city bid, through this proper city bid that contained no agreement to arbitrate or anything else.
All right, so you're saying none of the 104 payments had to do with the shirts or pants that were supplied to the tax collector?
Some of them may have been items that were supplied to the tax collector. In fact, I presented evidence that bills were paid through the tax collector. I think it's important, Your Honor, to understand that...
What changed? Why did the city suddenly shift position?
The city did not shift positions, Your Honor. This was a supply contract that basically set prices for all the agencies and all the independent agencies and departments of the city through the central purchasing office, the procurement office. And the supply contract means that basically the city was not obligated to buy anything. It just set prices, and then the departments, each of the departments or agencies, in the case of the tax collector, the sheriff's office, the various departments of the city, public works, they would order against this central purchase order. and then they would receive that pricing.
But specifically excluded were these Oxford shirts and the polo shirts.
Specifically, Chief Judge Hawks, that's exactly right, and that's what I was about to say, that Unifirst had an opportunity to bid on colored polo shirts. They no-bid the colored polo shirts. And that was when they submitted their bid in 2004 and was awarded a contract starting the fiscal year beginning October 1st, 2004. Then all of a sudden in 2005, they put this document in front of the tax collector, someone in the tax collector's office, and they, you know, and that's what they're stating is the basis of their whole agreement with the city and obligation to arbitrate. But, you know, the arbitration, jurisdiction arbitration, unlike court's jurisdiction, is conferred by agreement of the parties. And the city has contested all along. There was no agreement because that particular document wasn't a proper city contract. The city contract was the contract in which you first bid.
Did the city pay for any collared shirts?
You know, Your Honor, I don't think that's established clearly in the record. The city did pay all along, paid Unifirst for the products that were ordered. Now, they paid for products that were ordered through the tax collector and through the other departments, and we submitted evidence to that effect. What happened was the tax collector just decided, okay, I don't want to buy from Unifirst anymore. And so as of the end of 2007, and this was let me just back up a second if I might. This was basically an award of a one-year contract. The city can only award 1 year at a time, subject to funding, with 4 options to renew at the city's auction. So the city renewed this blanket contract with Unifirst, and any of the departments each year could issue purchase orders against it. Well, the tax collector did for the first 3 years. At the end of fiscal year 2007, the tax collector said, I don't want to order from Unifirst anymore. It didn't cancel anything. It just stopped ordering through the bid. And that was then all of a sudden the basis of the claim by Unifirst that there was somehow a cancellation or a termination. But what's curious...
So as a fact of the matter, they never furnished goods that were not paid for?
No, sir. No, sir.
So they're just claiming the setup or whatever they did at their factory
Exactly.
caused them expense?
Yes, sir. That is correct. Judge Benton, you were also talking about, I think you asked Mr. Sanders, who should make the decision, the court or the arbitrator, and clearly it is the court, and there's solid case law on that. The idea that a party would have to submit to arbitration on an agreement that it contests the very existence of is just absurd. And the court below, and the law is very clear, starting with the Supreme Court case of Seaford and the cases I cited in my brief, that basically the court has to make that decision. It's clear in the arbitration code. The court makes that decision. If there's any question as to the validity, not the validity, but the existence, the very existence of the contract. And to say that the city didn't object or didn't raise that early on is just a misstatement of the fact. I didn't handle the initial part of this. I handled this case when it was filed as a motion to confirm arbitration. But our chief deputy counsel, Cindy Laquadera, handled this at the outset. And when the demand was made for arbitration, which wasn't made in the court, it was just when the intention to arbitrate was communicated to the city turned around and wrote to the AAA, to the American Arbitration Association, copying Mr. Sanders, and I'm sure and I know it's not in the record, but had several conversations with Mr. Sanders, various attorneys in our office, and objected to the arbitration on the very grounds that I'm standing here today, and that our response is based on. That the employee in the tax collector's office had absolutely no authority of the city to sign that document.
Now, this whole question about New York law is a complete red herring. For one thing, their position rests on a paragraph in the contract, which the city's position is never came into existence.
That's correct, Your Honor.
For nothing did they ever plead that our law applies.
No, sir, they didn't. They filed their motion to confirm the arbitration under the Florida Arbitration Code. They argued under Florida law throughout this whole thing. I think the first time I saw that it was raised, I mean, it was raised in the hearing somewhat, and then more so in the brief. But I think as the city briefed, the outcome would be the same under New York law. But no, the initial inquiry, of course, whether this agreement was binding on the city, determines whether there's an arbitration clause at all that's binding, whether New York law applies, and any kind of cancellation penalty. So you can't, to quote from the arbitrator's decision is just, I think you mentioned putting the cart before the horse. You can't, that arbitrator basically didn't have jurisdiction. If you accept the proposition that this contract was not a valid city contract, then you have to then say, well, then there was no jurisdiction for this arbitrator, and the arbitrator shouldn't have made that decision. What should have happened, if Mr. Sanders' client was so intent on taking this to arbitration, they should have brought it before the court sooner. It was, I think he mentioned it, Mr. Sanders mentioned it in their brief, but that somehow it was the city's obligation to file a motion to stay, and it's absolutely not the law at all. The city shouldn't have to go to court every time somebody asserts that there's a contract against it. That would just not.
Even though Mr. Amos signed, and he said that, I guess above the signature, the undersigned attest to have the authority to execute for the named customer.
Your Honor, there's
That doesn't make it a contract that binds the city of Jacksonville.
unfortunately does not.
I wonder if the city of Jacksonville did in fact mail payments by mistake under what was provided under this contract. That doesn't make it a contract if you send money if you send them money.
It does not, actually, Your Honor. There's no implied contract when you're dealing with a public entity, actually. And I cited a case in there. There's not an estoppel issue here. If the formalities of a city contract are not followed according to the ordinance code, then there is no contract.
And Unifirst understood what was necessary to get a contract for the city of Jacksonville by having gone through the process.
They absolutely did, Your Honor. They absolutely did, which makes this even a little bit more absurd, is that they brought this lawsuit at a time when they had a valid contract with the city and were supplying uniform services with the city, and were getting paid thousands of dollars a year, upwards, I believe, and I'd have to look back in the record, but I believe it was close to $100,000. It was a substantial amount of money that the city was paying Unifirst every year under this citywide blanket purchase order to supply uniforms of every kind. And it was just so for them to then sue the city saying, well, you terminated the contract when we were actually in the midst of a contract, and that just ended in September of 2009. So during this whole period of the lawsuit and most of the appeals, back when I was writing the brief, the city had a valid contract because the city continued to renew the contract with Unifirst in spite of the fact that it had been sued to supply the uniform services for the remainder of the term. I don't make those decisions, Your Honors. I just report them.
Opposing counsel said that the record before the court was inadequate as a factual matter to support the conclusion that the contract did not come into existence.
Well, Your Honor, I think that's one of the issues that Unifirst is raising, and I think it goes to what they're raising in their authenticity issue. And first of all, the standard review on that is clearly erroneous, and Judge Schemmer below made the determination that the documents were authenticated. First of all, many of them are public records, since they're self-authenticating. Second of all, I had the chief procurement officer for the city testifying, and he is he may have clerks that work for him that actually put the documents together, but his signature was on many of those documents that we brought in front of the court. The court made the determination that those were valid city documents, and that, so we did present evidence concerning the contract.
But now you
I
say the
disagree with that.
testimony itself would have been enough to support the trial court's findings
I'm sorry, the testimony of who, Your Honor?
of the fiscal person,
The chief procurement officer?
chief procurement officer.
Well, I think it's a combination of both. I think the documents themselves are public records, and they're self-authenticating. I think that the court can also take judicial notice. It's not clear, he didn't maybe use those words, it's not clear, but the issue was vigorously argued below by Mr. Sanders, and he objected to the admission of the documents that the city, that the court ultimately admitted, and yet the court decided to admit those documents. I had Mr. Clapsaddle there in the event that we needed, we needed somebody to authenticate documents. I think I would like to just point the court, to one case that actually was one of the members of this panel actually was on that panel. I believe it was you, Chief Judge Hawks. And it really it discusses a lot of the issues we're talking today. And I cited it in my brief, but I did not discuss it. And it's Rowe Enterprises versus International Systems, and that's found at 932 Southern 2nd, 537. And I think that one is an important case, obviously because it's in the first DCA, and also because it talks about the whole issue of what a party needs to do if an agreement is challenged, and also who decides that, and also, I guess I would add, whether that party would be subject to the time limitation in which to object, which again, if there's no agreement to begin with, then there's no obligation to object within that time period. And the cases cited in there also refer to the 11th Circuit and the other federal cases that I refer to in my brief, basically for persuasive authority, because the Federal Arbitration Act and the Florida Arbitration Act are very similar in these regards.
Is it your position then that the appellant's claim is meritless, completely meritless?
Your Honor, it is. It is.
Did you seek to obtain fees under 5705?
No, sir, we did not. No, sir, we did not. And I would just ask if the court doesn't have any additional questions, that the lower court be affirmed. And I'll thank you.
Good morning again. Unless there's a specific question, I'd just like to go over some of the things that were testified. I believe that you were pointing out with regards to I guess the evidence or the record that's before the court. The mere fact that a gentleman comes in front of the lower court and says, I authenticate these records, is not testimony. It's not evidence. It is not something that the court waded through every single document, and you have it before you on the record. In the
Now, she said some of these records are public records and self-authenticated.
Well, and some of them may have been, but not all of them were. And it was a very large packet. In fact, we had...
Why isn't the ordinance itself, why is that adequate to set out what is required in order to enter into a binding contract?
Well, and again, I think Chief Justice Hawks pointed out that somebody asked a question about assumption of knowledge. I don't think we can assume that, because that's not in evidence before the lower court.
But my question is, did your client think that this gentleman at the tax collector's office had the authority to enter this contract? And this is relating to the question earlier of you, which is, your client had successfully obtained a contract with the city and had gone through the proper central procurement process, and then is contacted by the tax collector's office for this side agreement. And I don't see any kind of meritorious claim that the party had the authority to contract with you.
And again, I think if you look at the record as a whole, I believe the evidence is there. And again, the only evidence is that testimony of Mr. Weghorst. The authentication of records is what I don't necessarily consider that evidence about the contract and how it was entered into. Mr. Weghorst, in his testimony, said they met together approximately about the same time that this contract bid was going into place. That's why it was pointed out by Ms. Lacadera that there was no bids on the contract with the city. The reason why there's no bids on the contract because the tax collector and them were already negotiating the polo shirts because the polo shirts were not going to be paid by the city of Jacksonville. The city of Jacksonville said we don't want to be having polo shirts as a part of our bid. That's what the tax collector did. So they started negotiating about the time of this contract. And this is Mr. Weghorst's testimony for approximately a month, 6 to 8 people. And they keep pushing in the brief, and that's why I feel that there may be an attempt to maybe possibly mislead, but they keep referring to Mr. Amos as a city employee. This city employee did this. This city employee did this. This was the chief assistant to the tax collector's office that met with my client over the course of a month requesting documents. And again, it was paid for, and I believe, again, Judge Benton brought this out, it was paid for around 52 weeks on a part of an invoice that went out weekly that says this is part of a contract. You just don't get to pick and choose when you can and cannot enforce a contract. They were expecting...
So it's your position that the chief assistant in the tax collector's office had the authority to bind the city?
And as pointed out by Chief Justice Hawks, that's exactly what the contract says, just
I know
above
what
the
the
signature.
contract says. Is it your position that that person has the authority to bind the city of Jacksonville under the city's law?
Well, and again, it's not my opinion that matters, it's Mr. Weghorst. And Mr. Weghorst believed at the time that he was negotiating and contracting with the city tax collector office that Mr. Amos had the authority. In fact, I think he indicated that the negotiations first started with a Mike Brown at that particular office. And then
Mr. Brown would have the authority also.
Well, possibly he would have the...
Anybody that signed this contract underneath this that said that they had the authority, your client was reasonable to rely on that they had the authority, in spite of what any ordinance might say or your client's actual experience in dealing with the city of Jacksonville.
Well, and again, I don't think there's any evidence, and I agree with you, I believe based on what you're saying, there's no evidence before the court to show that my client knew the propensity of the entire agreement of the city ordinances. There's no testimony by any city employee that says, yeah, when we met with him, we explained to him that this was illegal because it was not a part of the bidding process. I can assure you that my client probably would have ceased negotiations at that point in time, and I apologize for going there. Thanks.
With that, the court will stand in recess, and we would invite you all to join us for coffee in the Dean Suite. And I'm going to ask the clerk to explain to you how to get there, although he has told me several times.
Downstairs, towards the parking lot in front of the building, where the women's are to the left, followed by the ramp, between 370. And I'll go down there.